Good morning, everybody. For some of y'all, this afternoon is 12:11. Welcome, everybody. Welcome. We're about to read some more of this paperwork. Just came in. How's everybody doing? Let me see who's here. Just a minute here. What's up, Mom Life? How you doing? What's going on? Black Girl Beauty, good morning. Good afternoon. I'm going to say good afternoon. Hey, Sharice, how are you? All right, I minimized myself over here in the corner, so I'm not taking up the screen. Hi, baby. Thank you. All right, y'all. So, for those of y'all, give a couple people a little bit of time to get up in here. If you would, when you come in, please hit the like button. I'd appreciate it. We're going to get through this paperwork real quick. Hi, baby. Hi. You still sleepy? You sleepy? Daddy can't put you on camera because your hair ain't done. Hey, Lady Eugenia, how you doing? Karen J, hey. Mom Life, Jennifer. Miss V, hey. Daddy can't show your hair. Okay. Come on. KK! You go with KK? Hair not done, baby. Can you come get her? I don't want to put her on camera because her hair ain't done. I know your mama don't like that. Hi. Yeah. All right. Thank you. Okay, y'all. Let's get to it. Hey, what's going on? All right, here we go. All right, we got about 20 people in here. Okay, y'all. We about to go through this paperwork. This was just released this morning. United States District Court Judge, Eastern District of New York, United States of America against Robert Sylvester Kelly, also known as R. Kelly. So this here is a memorandum of law in support of the government's motion in Lamine to protect the identities of certain victim witnesses. Oh, wow. It's going to be interesting. This is from the government, Jacqueline M. Casoulis, which is the acting United States Attorney for the Eastern District of New York. Turn this off. Hold on. All right. Here we go. So, this is Elizabeth Jettis, and I guess these are all of the attorneys for the government that is on the government side. So let's see here. Let me raise this up. Okay, is that whole page 1? Okay, that's page 1. Okay, let's go to page 2. All right. It says here, preliminary statement. The government respectfully submits this memorandum of law in support of its motion in, I think that's Lamine, in advance of trial in this matter, currently scheduled to commence on August 9th, 2021. This motion in Lamine seeks to protect the identities of certain charged victims referred to as Jane Doe number 2, Jane Doe number 3, and Jane Doe number 5. In the third superseding indictment, hereinafter referring to as victim witnesses, that are expected to provide and or will be the subject of sensitive and personal testimony concerning illegal sexual abuse, sexual contact, and other acts committed by the defendant at trial. Specifically, the government moves the court to number one, permit the victim / witnesses to testify using a pseudonym, I guess that's what it is, pseudonym of their first names only. Number two, limit references to each of the victim witnesses in open court to their personams. Okay. Personams of their first names only. Personams, however you say it. And number three, prevent public disclosure via cross-examination of or otherwise of the victim / witness respective addresses, names of family members, or exact place of employment, if any. For the reasons set forth below, the court should be granted the government's motion. Okay, so it looks like they are about to make sure that they are not getting doxxed by you know who. Let's see what the government got to say. Let me do this. Here we go. It says here, background. The charged conduct. On March 12, 2020, a grand jury in the Eastern District of New York returned a 9-count third superseding indictment, called the indictment, charging the defendant with: the government intends to file a motion to admit other acts, evidence as direct evidence of the charged racketeering offense and as evidence admissible under Rules 404B and 413 of the Federal Rules of Evidence. In connection with that motion, the government also requests that certain victims / witnesses of the other act's evidence to be permitted to testify using personams. I think that's the word, y'all. I think that's the word. I could be wrong. Personiums, whatever that is, of their first name only. Okay. Let's go to page 2. It says here, racketeering and the alleged 14 racketeering acts, including bribery, sexual exploitation of a child, kidnapping, transportation of minors and individuals for the purpose of engaging in illegal sexual activity, illegal coercion and enticement of individuals, and forced labor, as well as violations of the Mann Act related to the transportation of individuals, including a minor, for the purpose of engaging in illegal sexual activity, the illegal coercion and enticement of individuals, including a minor, in violation of 18 U.S.C. 2421, 2422, and 2423. Among the charges are offenses that carry a 10-year mandatory minimum sentence. The defendant's alleged victims are identified sequentially in the indictment as Jane Doe number 1, though Jane Doe through Jane Doe number 6. So if you look at this, y'all, from what I'm seeing here, if he's convicted on each one of these Jane Does, that carries a minimum 10-year sentence apiece. Not unless they group them all together, but I would assume that, he could be convicted of guilty of Jane Doe number 1, but not Jane Doe number 2. However, but that's 60 years right there if it says that the offenses carry a 10-year mandatory minimum sentence. Okay? Let's move on. The charged victim witnesses. The government anticipates that the charged victims, Jane Doe number 2, Jane Doe number 3, and Jane Doe number 5, will be called as witnesses at trial and will also be the subject of testimony and other evidence elicited at trial. Well, now we see that I know a lot of us believe that Jane Doe number 5 is AZ. So all of the speculation about if she's going to be speaking is right there. Just read it. Jane Doe number 2. The indictment charges the defendant with racketeering, including predicate racketeering acts involving Jane Doe number 2, an individual whose identity is known to the government and the defendant. Jane Doe number 2 is expected to testify that she met the defendant in or about 1999 in Chicago when she was 16 years old, after a member of the enterprise approached her at a fast food restaurant and informed her that the defendant wished to speak with her. Thereafter, while Jane Doe number 2 was a minor, under the age of 18, the defendant engaged in sexual conduct with Jane Doe number 2 and, on multiple occasions, filmed Jane Doe number 2 having sexual intercourse with the defendant, therefore producing child pornography. So, it says that he did videotape himself with Jane Doe number 2 while she was under the age of 18, which is child pornography. You see how they're tying all of this together. We just reading the facts, y'all. Just reading the facts. Here we go. Page 4. Jane Doe number 3. The indictment charges the defendant with racketeering, including predicate racketeering acts involving Jane Doe number 3, an individual whose identity is known to the government and to the defendant. So what they are saying is that he had the 3500 material, y'all. They're saying that he has the information to know who these Jane Does are. So when they was trying to spin that saying he don't got no information, hey y'all, do me a favor. Please hit the like button. I see 23 people in here, only 11 likes, and I see 2 dislikes. So they not liking this. We are reading paperwork. Y'all know how they get when we read paperwork. Please hit the like for me. Thank you very much. So it says here that Jane Doe number 3 is, let me make sure I read. The indictment charges the defendant with racketeering, including predicate racketeering acts involving Jane Doe number 3, an individual whose identity is known to the government and the defendant. Jane Doe number 3 is expected to testify that she met Kelly in 2003 at a mall outside the state of Illinois when she was in her early 20s and working as a radio station intern. The defendant therefore invited Jane Doe number 3 to travel to Chicago, Illinois, purportedly to conduct an interview of him in connection with her employment at the time. So he pretty much tried to help her and say, hey, I can help your career get better. I'll give you an official interview with me. I'm at the prime of my career. Come on up here. I'll fly you in or whatever, and I'll give you an interview and then help start your career. Following her arrival in Chicago, Jane Doe number 3 was directed to a recording studio. Once there, she was escorted to a room within the studio by one of the defendant's associates, who also took and searched her suitcase. Later, while in the room, another associate made a copy of Jane Doe number 3's driver's license, directing her to sign what she believed to be a non-disclosure agreement, and advised her not to talk to anyone and to keep her head down. Jane Doe number 3 ultimately spent approximately 3 days in the room, which was locked without sustenance. After a member of the enterprise eventually provided her with food and drink. So how long did they make the doggone girl wait before she got some food and drink? After a member of the enterprise eventually provided her with food and drink, she became tired and dizzy. She woke up sometime thereafter and saw that the defendant was with her in the room and that her underwear had been removed without her acknowledgement or consent, which in combination with other circumstances made it apparent that the defendant had sexually abused her while she was unconscious. Oh, hell no. Whoa. Damn, so he drugged her. Or the Enterprise drugged her to get her knocked out so that he could take advantage of her. God damn, they so ruthless. Jane Doe number 5. Damn, that's messed up. The indictment charges that the defendant with racketeering, including predicate racketeering acts involving Jane Doe number 5, an individual whose identity is known to the government and to the defendant. He is also charged with substantive Mann Act violations, including Jane Doe number 5. Jane Doe number 5 is expected to testify that she met the defendant in or around 2005 in Florida when she was 17 years old, after a member of the Enterprise approached her at a concert and gave her the defendant's phone number. Therefore, while Jane Doe number 5 was a minor under the age of 18 and in violation of applicable state law, the defendant engaged in sexual relationship with Jane Doe number 5 and on multiple occasions filmed them engaging in sexual intercourse, thereby producing child pornography, which means they have proof that he had sex with her under the age of 18. For all of y'all out there that's just saying, oh, well, they don't have proof, and maybe he did after she was... No. It's while she was a minor. They have proof. There's your proof right there. Multiple occasions, by the way. As a result of the defendant's actions, Jane Doe number 5 contracted an incurable sexually transmitted disease at the age of 17. Let me read that again for the slow people on the other side. As a result of the defendant's actions, Jane Doe number 5 contracted an incurable sexually transmitted disease at the age of 17. In addition, the defendant used physical force, threats of physical force, physical restraint, and threats of physical restraint, and other means of psychological coercion to cause Jane Doe number 5 to engage in sexual activity, not just with the defendant, to which Jane Doe number 5 did agree to, but also sexual activity with many other women and a man. The sexual activity with others was always at the defendant's discretion and in the defendant's presence, and often filmed for the defendant's use. Argument. At trial, the government expects that the victim/witness will testify about and or be the subject of testimony and other evidence relevant to the crimes charged in the indictment. Due to the sensitive nature of the testimony and evidence as noted above, the government moves in Lyman, for the court to, number 1, permit the victim/witness to testify using their first names only, or Passalums, whatever that is. I'm sorry, y'all keep murdering that word. Number 2, limit references to each of the victims / witnesses in open court to their first names or Passalums. Number 3, prevent public disclosure via cross-examination or otherwise of the victim / witness respective addresses, names of family members, or exact place of employment, if any. Y'all already know that the other side already got all this damn information. They've been doxing and doing all this shit from day one. So, sorry government, but they already got it. Here we go. Measures are necessary to protect the victim / witnesses from potential harassment from the media and others, undue embarrassment, and other adverse consequences. Legal standard. The Confrontation Clause guarantees defendants in all federal and state criminal prosecutions the right to confront government witnesses testifying against them. They cite case law, California versus Green. This right here, however, is not absolute. A defendant's rights under the Confrontation Clause must yield to accommodate other legitimate interests in the criminal trial process. They cite more case law, Chambers versus Mississippi. For instance, the Supreme Court has observed that there is wide latitude insofar as the Confrontation Clause is concerned to impose reasonable limits on such cross-examination based on concerns about, among other things, harassment, prejudice, confusion of the issues, the witness safety, or interrogation that is repetitive or only marginally relevant. Delaware versus Van Arsdale. In deciding whether to limit the scope of cross-examination, the court must balance the government's reasons for requesting such limitations against the defendant's interest in full cross-examination of the witness. See Alford versus the United States. If the question asked is one that is normally permissible, the state or witness should at least come forward with some showing of why the witness must be excused from answering the question. The trial judge can then ascertain the interest of the defendant in an answer and exercise an informed discretion in making this ruling. In trial context, courts have found that the potential for reprisals, humiliation, or annoyance are sufficient to justify non-disclosure of personal identifying. Let's go to the next page. All right, let's do this. Here we go. Okay, it says information as Honorable Aline R. Ross District Court in the Eastern District of New York has summarized. In advancing the contention that the defendant's rights under the Confrontation Clause of the Sixth Amendment require full disclosure. Oh! This is why when they presented that motion for him to be released, they talked about them not having enough time to go over the paperwork would violate his Sixth Amendment right for him to have. Now it's linking up. Okay, so it says of the Sixth Amendment require full disclosure of the witnesses, names, place of employment. Oh, hell no. Oh, hell no. They still fighting to get all this information so they think they slick. Place of employment and home addresses. Why the hell you need the home address of a witness for? Don't you just need their name and what they said? Y'all, please help me get them lights up. We got 19 lights and 35 in here. Please hit the like button. Okay. Says here, taken together, these cases have been, have been interpreted by the Second Circuit to safeguard two main interests of the defendant. Number one, obtaining information needed for in-court and out-of-court investigation of witnesses, and enabling defense counsel to elicit information that might be relevant to the jury's deliberations as to credibility and knowledgeability of the witnesses. See United States versus Marty. In the event the government seeks to limit disclosure of identifying information in open court, the government must provide a reason for the limitation. ID citing Smith, that's more case law. The reason may be that the answer may subject the witnesses or the witness to reprisals, or that the question is being used to humiliate or annoy the witness. The defendant is required to demonstrate a particularized need for disclosure of the relevant information, which the court weighs against the risk to the witness. See United States versus Bennett, and they cite more case law. United States versus Marcus. Okay, boom, boom, boom. In Marcus, that was the case law before. United States versus Marcus. It says in Marcus, the court relied in part on United States versus Marty, in which the Second Circuit analyzed the Supreme Court's holding in Smith and Alford, and ultimately concluded that there is no prejudice to the defendant, where he was precluded from requiring about a witness address. Yes, that's what I want to know. Why do y'all need the witness addresses? See Marcus 2007. Okay, the Marcus court, or the Marcus held that although the government should come forward with a reason for withholding the witness's address, the reason may be that the answer may subject the witness to reprisals, or that the question is being used to humiliate or annoy. Okay, let's do this. Annoy the witness. ID ruling that potential harassment, potential loss of employment, and the explicit nature of anticipating testimony are legitimate reasons to protect witnesses' full identity and to exclude mention of witnesses' home addresses and current places of employment. Accord United States versus Pepe. Finding no error in precluding cross-examination regarding witnesses and home addresses. United States versus Navarro. Cross-examination of the informant about his home address and current place of employment precluded. United States versus Harris. If the answer may subject the witness to harassment, humiliation, or danger, then disclosure of the witness' home address may be justifiable. Anyone on this side knows that if any of those jurors or witnesses' information is leaked, people will visit their jobs. We have seen evidence of that happening. People will look outside your house. People will call and harass your family, look up your family, post your kids, post your information out here, which will put you in danger of possibly being hurt or killed because you are going against their guy. If the answer may subject the witnesses to harassment, humiliation, or danger, then non-disclosure of the witness' home address may be justifiable. United States versus Austin. As the Marcus Court concluded, the relevant precedent looks to whether the information is necessary to the defendant in order to engage in or out of court investigation of the witness, or to attempt to discredit the victim before the jury. In addition, the Second Circuit has upheld non-disclosure in full identifying information in order to protect the safety of the witness and his or her family. Y'all, what's crazy about this as I'm reading it is we are seeing this stuff happen that they're trying to protect these witnesses from. We're seeing it happen right now. We've seen it happen over the last couple of years. This is insane. In addition, the Second Court has upheld non-disclosure of full identifying information in order to protect the safety of the witnesses and his or her family. Government witnesses in the Witness Protection Program permitted not to disclose his occupation. United States versus Baker. They cite a lot of case law, y'all, to prove to this judge that this is necessary. 2 government witnesses permitted to conceal addresses and places of employment. Hold on. Where the government seeks to limit disclosure of the witnesses' identifying information in court, the government must articulate a need for withholding the identifiers. Next page. Such as fear of reprisal, humiliation, or annoyance to the witness. Once the government identifies a need to protect the witness, full identity, the defendant must demonstrate a particularized need for the information which the court weighs against the harm to the witness. Marcus 2007. In Marcus, Judge Ross expressly found in a case involving sex trafficking allegations that in light of the explicit nature of the conduct that the witnesses will be testifying about, the court has determined that the witnesses' fear of harassment and reprisals is legitimate. Similarly, in another trial case in this district, the Honorable Sandra J. Feuerstein, then District Court Judge of the Eastern District of New York, also permitted victims testifying in graphic detail about acts of forced prostitution and sexual contact with customers and others to testify using their first names only. See order dated April 26, 2011 at 2 United States versus Rivera. In addition, in a case where the defendant was charged with abusive sexual conduct and assault on an airplane, the Honorable Carol A. Ammon, District Court Judge in the Eastern District of New York, permitted the victim witness to testify using her first name only. See transcript of April 5th, 2016 pretrial conference. In United States versus Richard Martinez, the Honorable Brian M. Cogan, District Court of New York, permitted a victim/witness to testify at trial using the personam in the case involving testimony of a similar nature where the defendant was charged with crimes involving sexual abuse. See order 2 and 3. Okay, so they cite a lot of case law. All right, let's go to page 10. It's 15 pages, y'all, so we ain't got long to go. Here, Jane Doe is expected in explicit detail about, is expected to testify in explicit detail about allegedly being the victim of degrading and humiliating treatment by the defendant. The case has already received significant national and local press coverage. Revealing Jane Doe's identity would likely cause her anxiety and risk social stigma. More broadly, requiring Jane Doe to disclose her identity would chill the willingness of the alleged victims of sex crimes to come forward. Furthermore, defendant has not identified any particularized need for the disclosure of Jane Doe's identity information in open court. The defendant already knows who Jane Doe is and will not be prevented from mounting a defense in the event that she is referred to as Jane Doe. Additionally, although her address, family members, names, and place of employment are entirely irrelevant to her testimony, disclosing these details and risk allowing third parties to identify her. Who do y'all think third parties are? Let me see who in here is smart enough to identify who the government is talking about when they say third parties would identify all their information if it was given out in the open. Let me see if one person can get it. Who do y'all think they're talking about when they talk about third parties identifying witness information, their family names, their family addresses, where they work, who their baby daddy is, where he work at, who their baby mama is, who their cousin is, grandpa, great grandma? Who do y'all think will be the third party? Let me see if anybody in this chat has any idea on who the third party would be. There you go, right there. Bloggers. Yes. Third party people. These people on this freaking internet. They're going to be the ones. That's right. The supporters. Okay. Y'all smart. Y'all got it. YouTube. That's right. Y'all got it. Okay. I'm moving on. Moreover, at certain sentencings, sex traffickers, court in the district have permitted victims to give in-court victim impact statements using only their first name or the name Jane Doe. Permitting victims to make statements using personams and noting that victims were permitted to testify at trial using nicknames, first names, or personams. See also United States versus Angel. Analysis. The limited protections requested by the government for the victim/witness personal identifiers are reasonable and necessary and appropriate to protect their safety and well-being and avoid harassment of victim/witness by the press and others and prevent undue embarrassment and other adverse consequences. So let me help y'all. Bloggers out there, minister of information, whatever y'all call her, whatever warrants, all them. All the information that y'all sent to them folks that went and blew her car up, put gasoline around their house, all that is the stuff that the government was trying to protect them from. Now, but y'all have already done all the things that they're trying to prevent happening to these victims. So why the hell don't you think you're going to jail, lady? I heard this lady say, I've done nothing wrong to go to jail. I've done nothing wrong. You were the cause of her information getting out, which means while her car got blown up, her family got threatened, had to move. Your ass definitely going to jail. There's no way you can't. Your actions caused the reaction of why they had to put a stamp on what we're talking about right now, which is protecting these people that have a right to come out and speak out against the injustice done against them. Period. Moving on. Says here, the limited protections requested by the government for the victim witnesses. Personal identifiers are reasonable, necessary, and appropriate to protect their safety and well-being and avoid harassment of the victim/witnesses by the press and others and prevent undue embarrassment and other adverse consequences such as retaliation by the defendant's supporters. Whoa. Whoa. Let me read that one more time. It says here, the limited protections requested by the government for the victim/witnesses. Personal identifiers are reasonable / necessary and appropriate to protect their safety and well-being and avoid harassment of the victim/witnesses by the press and others, and prevent undue harassment and other adverse consequences such as retaliation by the defendant's supporters. Need for relocation. Houston, Texas, you an idiot. You are one. You keep coming in my chat and talking about you are idiot if you don't understand that. A straight idiot. Her ass definitely going to jail. And you probably one of them ones under that fake profile that's helping her do this little stupid stuff. Stupid people. Anyway, says here. Matter of fact, get her ass out of here. Get Houston, Texas out of here. I don't know how you keep getting on my channel anyway. Says here, the victim witnesses are expected to testify in explicit detail and or the subject of highly sensitive and personal. Hold on. All right. Says here, Jane Doe is expected to identify in explicit detail about allegedly being the victim of degrading and humiliating treatment by the defendant. The case has already received significant national and local press coverage. Revealing Jane Doe's identity would likely cause her anxiety and risk social and risk social stigma. More broadly, requiring Jane Doe to disclose her identity would chill the willingness. Hold on, did I just read this, y'all? Hold on. Okay, yeah, I read that. Hold on. Okay, now we're on page 11. Okay, I'm sorry. Here we go. Testimony concerning their medical history and illegal sexual abuse by the defendant, some of which occurred while most of the victim witnesses were under the age of 18. Since the defendant's arrest, the case has garnered significant attention from local, national, and international media sources, which can only be expected to increase during the trial. The defendant's arrest and indictment received widespread coverage in the media, and the case has continued to receive significant attention given the defendant's career as a well-known musician and nature of the charges. The news coverage has not only centered on the defendant, but has also focused on victims, attempting in certain instances to identify unnamed victims in the indictment through various channels. In addition to the addition that the case has received from the press, the case has likewise garnered widespread. This right here talks about R. Kelly indicted on federal kidnapping, racketeering, and child sex related. Okay, this is stuff that they show on all of the media things they have on here. So y'all can look through here and see New York Times, all this kind of stuff, right? Okay, let's go to the next page. Says here, attention and discussion via multiple social media platforms such as Facebook, Instagram, YouTube, and Twitter. This attention has not only consisted of discussions regarding the case generally, but has included attempts by members of the public to determine the identities of the Jane Does named in the indictment and other potential witnesses, as well as online campaigns aimed at individuals presumed to be connected to the trial. Moreover, as the court is aware, The government has arrested and charged multiple individuals in connection with interference with this case, arising from conduct including arson, attempted bribery, and harassment aimed at a witness in this case. C. United States versus Don Russell, United States versus Richard Arline, and United States versus Michael Williams. Under these circumstances, maintaining the anonymity of the victim/witnesses is particularly appropriate. Significantly, despite the case's publicity, two of the victim witnesses, Jane Doe number 2 and Jane Doe number 3, have not spoken publicly about their experiences and instead have maintained their anonymity with respect to the allegations against the defendant. While Jane Doe number 5 has spoken publicly about some of her experiences with the defendant, her anticipated testimony at trial will be more fulsome than her prior public disclosures and will include sensitive information that has not been previously publicly revealed. Publicly revealed, the victim witness identifies Wood. This deals with the Surviving R. Kelly Part 2. What happened to Surviving Live's Facebook page. Newsweek discussing Facebook's removal of an account created with the purpose of discrediting the defendant's accusers and sharing their personal contact information, the creation of a number of copycat pages, and claims by reported accusers of harassment and receipt of threatening letters. Here we go. Also caused needless anxiety and social stigma, which concerns are further heightened by the defendant's notoriety. Is that right? Notoriety and the long memory of the internet. Moreover, requiring the victim/witness to provide publicly full identifying information does not serve any of the legitimate purposes identified by the courts, such as the defendant obtaining information in or out of court investigation or attempting to discredit the witness before the jury. Rather, requiring the victim/witness to provide their identifying information in open court would serve only to harass, embarrass, and to humiliate or annoy the victims. These purposes are directly at odds with the rights that victims are to be afforded under the Crime Victims' Rights Act, which include the right to be heard, but also to be treated with respect for their dignity and privacy. Indeed, requiring victims of sex crimes to provide their names in public would chill their willingness to testify for fear of having their personal histories publicized, which has already been done, and the embarrassment and humiliation that such publicity would cause them as they rebuild their lives. In addition, a ruling requiring the victim/witness to disclose their full identities publicly could cause other victims, including minor victims, to avoid seeking help from law enforcement because of fear that coming forward could subject them to further harassment and embarrassment, as well as retaliation by a defendant's supporters. Let me grab something to drink. All right. Against this well-grounded need to limit fully identifying the victim witnesses publicly, the defendant will be unable to articulate any popularized need for the disclosure of the victim/witness's identity information in open court. Counsel for the defendant is currently aware of the identity of the charged Jane Does, which will be confirmed by the government prior to trial and has or will be provided. Hold on. Discoverable statements for victims/witnesses in the government's possession. The reasonable limitations requested by the government, therefore, will not prevent the defendant from presenting a defense. Indeed, the identifying information the government seeks to limit in open court, including the victim/witness full names, specific employment, and family information, is largely irrelevant to the testimony of the victim/witnesses. There is a substantial risk, however, that disclosure of such information will identify the victim witnesses with particularly and thus subject them to harassment, retaliation, and embarrassment or additional consequences such as the need to relocate or loss of employment. See United States versus Bennett. The district court did not err in allowing government witnesses not to identify a place of employment where defense failed to demonstrate a particularized need. Conclusion. For the foregoing reasons, the government respectfully requests that the court grant the government's motion in its entirety and limit the disclosure of at the trial of the victims/witnesses personal identifying information and allow them to testify using only their first names or pseudonyms, whatever that word is. This was respectfully submitted by Jacqueline M. Casoulis, which is the acting United States Attorney. Also, Elizabeth A. Geddes, Nadia I. Shahida, and Maria Cruz Melendez, Assistant United States Attorneys. So, I don't know no other way to spin that, y'all, other than all this doxing that's been going on. Folks gonna see. The government been trying to protect these folks, but you got people out here that are thinking that they're investigators, thinking that they are helping this man's case by identifying the people that are putting their lives on the line. You thinking you helping him. But now you can clearly see that you've hurt him. And you've hurt his case. And yes, it might be embarrassing for you to be known as the one who has used your equipment or whatever resources you have to identify and dox these people and find out where they work and all this kind of stuff. It may be embarrassing to know that you are going to be a reason why his case is being hurt. But if this right here didn't make shit real to y'all, nothing will. You can't get around this. It's in black and white. They told you they have evidence. So y'all want to talk about how those 100 devices had nothing on them? Guess we'll find out. I ain't got no tea in here, y'all, but I had to sip on some cran grape on that one. Real talk. Real talk. There's no way to get around what we just read. There's no way. And I promise you, if I hadn't got on here and read it to y'all first, the other side, and they still will, go in there and try to twist it around and turn it and flip it into a way to say, oh my God, this is not bad, y'all. This is they don't have anything. They don't have anything. What you talking about, Willis? Yeah, Diva, please go live too, because you know you have a different perspective on it than I do. So please, Diva, if you go live, you know I'm gonna definitely support you, sis. But y'all, listen, that's all I had, man. I just wanted to get on here so I could go over this with y'all. Hold on. I see some comments here I want to post and let y'all. Let me see here. Let me minimize this. Bring this in. Okay. Yes. Lavish Lavender. I agree with you. These victims, their names, in their faces shouldn't have been displayed on YouTube. They've been harassing 24. You're absolutely right. I agree. And threatened. I agree. Yes, Diva, please go live. Please go live, Diva. We want to hear from you. Atmos, go back to the page with the media outlets. Okay. All right. Let me go back to the page with the media outlets. Hold on. Boom. Let me move my face out the way. Hold on.